This module is entitled Emerging Topics in Student Conduct, Online Harassment. I am Adam Wolkoff, Assistant Director at the Student Conduct Institute. This module's first learning objective is to review the balance between protecting free speech on campus and preventing sexual harassment. We'll go over several major U.S. Supreme Court decisions dealing with this challenge. Second, we will analyze how recent case law from the Fourth Circuit Court of Appeals addresses the Title IX duty of campuses to prevent and respond to sexual harassment online. Third, we will consider what's next in this emerging field, including the challenge of policing online content and new laws surrounding non-consensual pornography. As we move through this material, we will also consider what impact the Title IX Final Rule, issued in final form on May 19, 2020 by the U.S. Department of Education, may have on how colleges and universities address sexual harassment online. Colleges and universities are confronted with the daily challenge of balancing the free speech rights of students, faculty, and staff with their duty to prevent and respond to sexual harassment. This includes preventing harassment on the internet. An institution's Title IX duty to prevent and respond to sexual harassment extends to the internet to the fullest practicable extent. Institutions must be prepared for emerging trends in this field, including new location-based social media apps and non-consensual pornography, often called revenge porn. Where do campus free speech rights come from? Let's start with the First Amendment to the U.S. Constitution. I'm sure you are familiar with this amendment, but when's the last time you had the chance to actually read what it says? Notice that it says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble. This amendment on its face only applies to federal lawmakers, but it now applies to the states through the 14th Amendment. Because it binds the states, it also binds public colleges and universities, and its principles have been adopted by most private institutions as well, as free speech is embedded in academic culture and the basic mission of the university. Students, faculty, and staff have come to expect freedom of expression on campus, whatever the institutional type. What are the limits of free speech on campus? The landmark case on this question began with a student protest against the Vietnam War. In Tinker v. Des Moines Independent Community School District, 3 students attending a public school district's high school and junior high school were suspended for violating a policy that banned the wearing of armbands. These armbands were a form of silent protest against the Vietnam War. Represented by the American Civil Liberties Union, the students' case reached the U.S. Supreme Court in 1969. The court ruled in favor of the students, holding that they were engaged in pure speech that was entitled to comprehensive protection under the Constitution. Just because they were students did not mean they didn't have free speech rights. The court famously announced that students and teachers do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court laid out a balancing test that governs all public institutions of education, both at the K-12 level and in higher education. Administrators must balance the student's right to expression with the school's authority to prescribe and control conduct within the special characteristics of the school environment. In making rules governing expression, the Tinker Court made clear that schools cannot ban speech or expressive conduct like wearing armbands just to short-circuit a controversy. To justify a speech ban, undifferentiated fear or apprehension of disturbance is not enough. The school must have reason to believe that the expression would substantially interfere with the work of the school or impinge upon the rights of other students. Here, there was no substantial threat of disturbance. Of the district's 18,000 students, only a handful wore armbands, and just 3 were suspended. These students did not make threats of violence or commit violent or disruptive acts. No other students' rights were infringed upon through this protest. Tinker also makes clear that student free speech rights extend beyond the classroom itself. Students have the right to expression in the cafeteria, or on the playing field, or on the campus during the authorized hours. Since Tinker, the U.S. Supreme Court has identified categories of student speech that fall outside the First Amendment's protections. Lewd and offensive speech could be regulated. while political speech would receive more protection. Let's look at the example of Morse versus Frederick from 2007. If Tinker was like the purest of the pure in terms of speech, a silent protest against a controversial war, the speech at issue in Morse v. Frederick was a lot more muddy. There, a high school student in Alaska held up a sign across the street from his school at a torch relay for the 2002 Olympic Winter Games. The sign said, rather cryptically, "Bong hits for Jesus," with that exact spelling. The court did not exactly know what to make of this sign. It took seriously the school district's argument that the sign could potentially encourage drug use by children. In the court's view, this interfered with a serious pedagogical concern, as Congress had spent billions of dollars to support drug prevention programs across the United States, and stopping drug abuse was not an undifferentiated fear. Failing to act on the threat would send a powerful message to students that the school condoned drug use. The Supreme Court's most recent case on student First Amendment rights is Mahoney Area School District versus BL. In that case, a public high school student sent posts to her Snapchat friends that used vulgar language to criticize her school, softball team, and cheerleading squad. She sent those posts from her personal smartphone at an off-campus location and not during school hours. For this, the school suspended her from the junior varsity cheerleading squad for a year. While affirming that a school could regulate off-campus speech, the court held that the speech in question did not amount to a material and substantial disruption of the work and discipline of the school, so the school overreached in its discipline. While the decision does not directly address the First Amendment rights of college and university students, the decision outlines the constitutional balance that college officials will consider when regulating student speech off campus. Schools must balance their interest in protecting the class environment from substantial disruption with their interest in promoting student speech, even unpopular expression. Importantly, the court holds that a public school generally has the authority to regulate student speech that occurs off campus and through the internet, where it causes a substantial disruption, threatens harm to a teacher or fellow student, or constitutes harassment based on a protected category. But a public school's off-campus jurisdiction isn't limitless, and it cannot discipline a student for pure speech that is unpopular or that others find vulgar. So a critical takeaway is that off-campus speech, including internet-based speech, can be regulated by a public school, but most student speech enjoys First Amendment protections for which they can't be disciplined. And even if disciplining vulgar speech is within a school's interests, it seems unlikely that similar concerns will govern a conduct process within a higher education setting with adult students. So what do Vietnam protests and bong hits for Jesus have to do with policing online sexual harassment? The analysis here begins with Title IX of the Education Amendments of 1972. As a well-trained student of the SCI, you know that Title IX is so short and to the point it could fit in a tweet. All it says is that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. Since its enactment, the law has been interpreted to prohibit all forms of discrimination, including sexual harassment, and it's been interpreted to apply to virtually all public and private institutions of higher education. Under Title IX, colleges and universities have a duty to promptly respond to complaints of sexual harassment and sexual violence in a way that limits its effects and prevents its recurrence. In the decades after Title IX's passage, the Department of Education began fielding questions from schools about the interplay between Title IX and free speech. Court decisions had made clear that Title IX required schools to prevent and respond to sexual harassment, and the Department of Education, through its Office for Civil Rights, or OCR, had published guidance dealing with the issue. After a notice and comment period, OCR issued its revised sexual harassment guidance in January 19, 2001. The guidance explicitly states that Title IX is intended to protect students from sex discrimination, not to regulate the content of speech. It also directs schools not to be overbroad in policing speech. OCR writes that simply because a statement is offensive does not make it prohibited conduct. To constitute sexual harassment, the conduct must be sufficiently serious, meaning severe, persistent, or pervasive, to limit or deny a student's ability to participate in or benefit from the educational program or activity. OCR expects the offending conduct to be evaluated from the perspective of a reasonable person in the alleged victim's position, considering all the circumstances, including age. OCR offered a couple of examples about how this balance might work. In one, a creative writing professor has a reading list that includes books describing sexually explicit content, including scenes depicting women in submissive and demeaning roles. That type of academic discourse would be protected speech under the First Amendment, even if it was offensive to individuals, and there would be no need for Title IX action. By contrast, if a group of male students repeatedly targeted a female student for harassment on the school bus ride home from school, including making explicit sexual comments about her body, there would be a need for a Title IX response. Even though this interaction included elements of speech, that speech was threatening and demeaning and therefore not protected by the First Amendment. OCR repeated much of this guidance in a July 28, 2003 Dear Colleague letter on the First Amendment, which also remains effective and available online. OCR has also guided us through an October 26, 2010 Dear Colleague letter, also still in effect and available online, dealing with harassment and bullying. There, OCR directed schools creating anti-bullying policies that these policies also had to address misconduct resulting in discriminatory harassment, including sexual harassment. Harassment could include graphic and written statements, which may include use of cell phones or the internet. Keep in mind that when the 2001 guidance was issued, online harassment would have been largely limited to online chat rooms and email. Facebook, Twitter, and Instagram didn't exist. But by 2010, students, especially in higher education, were commonly carrying smartphones and texting more than they talked. So there was a renewed focus on the internet as the forum for exchange and potentially harassment. This 2010 Dear Colleague letter made clear that sexual harassment would include circulating, showing, or creating emails or websites of a sexual nature. And it noted that gender-based harassment includes anti-gay slurs posted on social networking sites. What was the school supposed to do? This 2010 Dear Colleague letter called for interventions to end harassment and discipline the harasser, such as separating the target and the harasser. But it said little to nothing about how to deal with the online environment. It did not specifically require digital interventions or online policing. 10 years later, on May 19, 2020, the Department of Education released its long-awaited regulations concerning how schools must respond to reports of sexual harassment under Title IX. The department found no conflict between these new rules and its long-standing guidance on online harassment contained in its anti-bullying Dear Colleague letter. Even though the final rule was released during the COVID-19 pandemic, at a time when most students from kindergarten to graduate school were engaged in online learning, the final rule said very little about online harassment. Within its 554 triple-columned pages, it made only a few passing references to whether schools had to address online harassment, when they had to do it, and how they should. The final rules indicate that the method of how the harassment is done does not matter. Whether it implicates Title IX depends on whether the misconduct meets the statutory definition of sexual harassment within the school's program or activity over which the school has substantial control. The department has left much gray area when it comes to the question of whether online harassment falls within a school's Title IX jurisdiction. The department affirmed that a school's program or activity encompasses all of their operations, indicated that such operations may certainly include computer and internet networks, digital platforms, and computer hardware or software owned or operated by or used in the operations of the recipient. So that language suggests that if a student is actually on the school's network and using the school's computers and software, then the school would potentially have responsibility under Title IX to respond to that user's harassing conduct. But what if that student is not actually on campus or on the campus's network? The department wrote only that a student using a personal device to perpetrate online sexual harassment during class time may constitute a circumstance over which the recipient exercises substantial control. Narrowly read, this language suggests that online harassment happening in class would implicate Title IX, even if the harassment is generated from a personal device like an iPhone or laptop. Read more broadly, class time might include asynchronous learning methods, such as online chat rooms and bulletin boards. If a professor knew that students were posting harassing messages on the bulletin board, then Title IX could be implicated. Of course, even if the department is signaling a narrow interpretation of Title IX in this context, and that is far from clear, a school can certainly create policies for online harassment that falls outside the Title IX definition of sexual harassment. Along with considering the specific issue of whether online harassment can fall within a school's Title IX jurisdiction, colleges and universities will at times sanction a student for online activity on professionalism grounds. For example, in Keefe v. Adams, an Eighth Circuit Court of Appeals case from 2018, a college removed a student from its associate degree nursing program for behavior unbecoming of the profession and transgression of professional boundaries, after it became aware of harassing posts on the student's Facebook page. These posts include remarks about the student's anger at other classmates and threats of bodily harm. The court specifically declined to make a broad brush rule forbidding a college from punishing off-campus speech, and it held that the First Amendment would not prevent a college from enforcing academic professionalism and fitness requirements, especially when training medical professionals. While a code of professional standards could not punish a student's religious views in speech, there was no evidence that that kind of impact was happening in this case, and that professionalism code could reach into off-campus speech as long as it is related to academic activities and material disrupts the program's legitimate pedagogical concerns. That link was established in this case because the posts were directed at classmates, involved their conduct in the nursing program, and included a physical threat related to those studies. We have very quickly covered two legal cornerstones of academic life today: the First Amendment and Title IX. Let's put them together. Under Title IX, sexual harassment is a form of discrimination prohibited by federal law. Stopping it is a compelling government interest. We know this from case law interpreting Title IX and OCR guidance on the matter, and its investigations into campuses that failed to prevent or address sexual harassment. If a school doesn't stop sexual harassment, it effectively condones it. This should remind you of the Bong Hits for Jesus case, Morse v. Frederick. Why was it okay for that Alaska school to discipline a high schooler for carrying that sign? Because there was a compelling government interest at stake, preventing teenage drug use. If the school didn't punish students for apparently encouraging bong hits, then it could be seen as condoning that behavior. Similarly, if a high school or college fails to address sexual harassment, what message does it send? Under this reasoning, a school was well within its rights to discipline harmful speech, even if that infringes on the right of the offending student to free speech. But the school cannot overreach. It cannot overreach in shutting down protected speech. Figuring out what's protected and what's not is at the heart of this balancing act. Now let's see how this dynamic plays out in a recent case before the Fourth Circuit Court of Appeals, Feminist Majority Foundation v. Hurley. Although this case is only binding on states within that circuit, it's likely to have a major influence on other courts considering these issues, and so it should be on your radar when it comes to preventing and responding to sexual harassment online. This was the Yik Yak case. If you aren't familiar with it, Yik Yak was a popular social media app available on iPhones and Android phones between 2013 and 2017, when it was shut down following a severe drop in usage. But at one point, it was a top 10 downloaded social media app. What made it unique was its hyper-local social messaging platform. It allowed users to create and view discussion threads called Yaks within a 5-mile radius. So it was popular among college students whose campuses generally fit within that radius. When a user posted a Yak, other users would anonymously vote that Yak up or down. Posts became more popular with more upvotes, which increased the poster's Yak karma. Yik Yak sparked immediate backlash across high schools and colleges, as it was identified as a source of severe cyberbullying. Many school districts and at least one college student government association attempted to ban the app, but others supported the app, saying that it gave voice to marginalized communities on campus and may have even assisted in preventing users' suicide. Yik Yak fostered a cyberbullying campaign at the University of Mary Washington, a public liberal arts university in Virginia. after members of a student-run feminist organization called the Feminist Majority Foundation spoke out about campus issues, including sexual assault and violence against women. Members of this group began to feel unsafe on campus as more than 700 yaks were posted threatening members of the group. Some yaks included threats of rape and murder. Others identified members of the group by name and included the member's location on campus so people could confront her in person. Some members also experienced in-person encounters stemming from these postings. These incidents were reported multiple times to campus administrators. The group demanded that the university disable Yik Yak on campus and ban the app from its wireless network, and then filed an OCR complaint. The university declined to disable or ban the app because First Amendment concerns about controlling student speech. The Feminist Majority Foundation took the case to federal court in Virginia, which dismissed their Title IX claim. This trial court reasoned that Title IX does not make a university liable for the sexual harassment itself, but for the university's response or knowing failure to prevent that harassment. Under the U.S. Supreme Court's 1999 decision in Davis v. Monroe County Board of Education, Title IX liability only exists where the university's response is clearly unreasonable in light of the known circumstances. This is a flexible standard that can vary based on considerations including the university's interest in avoiding disciplinary action that could subject it to constitutional or statutory claims. As a primary matter, then, the university was not Title IX liable, according to the trial court, because the harassment took place in a context over which the university had limited, if any, control, the internet, on a social media app run by a third party. Secondarily, if the university had undertaken to ban the app, the court reasoned that it could have been exposed to First Amendment liability. Because the 1999 Davis decision does not require institutions to take action in ways that could potentially subject them to liability, there was no requirement that the university undertake a broad attack on Yik Yak. So that was the district trial court's reasoning. The Feminist Majority Foundation then decided to appeal the decision. Their appeal attracted a lot of attention from interested advocacy groups. Amicus, or friend of the court briefs, were filed for both sides by advocates. The National Education Association and National Women's Law Center wrote on behalf of the students, criticizing the district court's narrow interpretation of Title IX as permitting the spread of cyberbullying and cyber harassment. On the other side, the Electronic Frontier Foundation wrote a brief favoring the university's position because it protected the value of anonymous speech online. Meanwhile, the Foundation for Individual Rights in Education, the Cato Institute, and the National Coalition Against Censorship raised concerns about the First Amendment and viewed the case as an opportunity to restrict the scope of Title IX. In a 2-to-1 decision, the Fourth Circuit reversed the lower court and sent the case back for further development. It held that, as a matter of law, if the institution has substantial control over the web platform and can exercise disciplinary authority over the alleged harassers, then it cannot ignore pervasive sexual harassment solely because the offending conduct took place through cyberspace. What gave the university substantial control? Yik Yak's unique features distinguished it from other social media platforms. The Feminist Majority Foundation Court noted that Yik Yak had a location-based feature, that the harassing and threatening messages originated on or near the campus, that some of the yaks posted using the institution's wireless network, and that the messages concerned campus events. Moreover, the court noted that the institution had the power to identify the yaks and disable their access to the campus network. Under these particular circumstances, the university couldn't turn a blind eye to the problem. What about the First Amendment? The court rejected the claim that regulating Yik Yak exceeded the campus's authority, given the level of threat and disruption to the student body. For one thing, this speech was not pure. The university had previously punished members of the rugby team for derogatory off-campus speech, so they also could have disciplined on-campus speech targeting the feminist group. In fact, many of the yaks amounted to true threats. Posts threatening rape and murder against specific students were true threats not protected under the First Amendment. In the court's view, these threats appear to constitute criminal conduct and should have spurred university officials to promptly identify the culprits. Regardless, the campus could have taken more steps short of totally banning the app to address the threat, including training the student body that it would not tolerate harassment in person or online. Where does the Yik Yak case leave us? And what should we be looking for in the future in the field of preventing and responding to online harassment? The Yik Yak case does leave us with a number of unanswered questions about Title IX and online sexual harassment. For one thing, are courts now more likely to second-guess universities' response to online harassment? It's rare enough that a reporting individual's challenge to a university's response can overcome a motion to dismiss, particularly where complicated technical and legal questions come in. But perhaps this case shows a new direction in the law. Yet the case, very problematically, does not tell us whether blocking Yik Yak or similar apps violates the First Amendment. The Fourth Circuit held that because the complaint alleged that the university could have taken steps beside barring Yik Yak on its wireless network to respond, it did not tackle the more challenging issue of whether the response itself would be unconstitutional. It could be that a future court addressing this issue would find in the university's favor, holding that a university could not block a social messaging app without running afoul of student free speech rights. Moreover, even if a university must regulate social messaging apps, does a university only have substantial control of location-based apps? If the app can be used globally, then it really should be considered outside of the university's control. Or not. Plus, what if the university lacks the technical capacity to expose anonymous users? Is it enough for a university to say that social media apps are run by third parties and outside the university's control? Must it involve law enforcement with cybercrime weaponry? These are major issues that remained unanswered from this case. The bottom line is that the landmark U.S. Supreme Court decision on Title IX liability, Davis, sets up a very high hurdle for reporting individuals to overcome. They have to allege facts showing that the university's response was deliberately indifferent. So, in a 2019 example from Washington State, Stewart v. Washington State University, a reporting individual's case was dismissed even where the university did not assist the reporting individual in addressing backlash on social media, including racial and sexual slurs, following an awareness rally held after the initial incident of harassment. Here we have similar facts to the Yik Yak case, a student threatened online in response to campus activism, but the university was not liable for failing to stop the cyber harassment. It could be that Feminist Majority Foundation stands as an outlier, given the unique location-based features of the Yik Yak app, and the plausibility that the university could control its use, an option that may be less true across the broader social media spectrum. One final note. Nearly every state, including New York, has passed laws banning the non-consensual publication of intimate images, better known as revenge porn. Some campuses have identified the distribution of non-consensual pornography as prohibited conduct within their codes. Consider whether your student code of conduct should specifically prohibit this form of misconduct, and train student affairs officials, residence life staff, and university police on handling issues arising from revenge porn and other forms of online sexual harassment.